Hey guys, thanks for watching Bond Court. I would really appreciate it if you hit the like button and subscribe to my channel. Bond Court is now in session.
Your name, sir?
Raymond Ferguson.
Mr. Ferguson, you're here for arraignment on your trespass charge. Is there an offer in the case?
An adjudication of guilt, credit time served, no return to the Highway Food Mart located at 700 West Church Street. There's also a cost of investigation of $93.76 to Orlando Police Department.
All right. Mr. Ferguson, you wish to accept that offer?
Yes, sir.
So you're going to enter a plea of no contest to the trespass, is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No.
You understood all the rights in the form? Do you have any questions about the rights for me?
No, sir.
You understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen. You understand?
Yes, sir.
All right, I do find sufficient factual basis. I will judge you guilty, be sentenced to 33 days in the Orange County Jail with 33 days credit for time served. I'll impose court costs, a $50 cost of prosecution, and a cost of investigation of $93.76 to the OPD. And you'll have 18 months to get that paid off. Finally, I'm going to order that you not return to the Highway Food Store at 700 West Church Street for a period of 1 year. If you do go back there and the court is made aware of that, you are subject to a contempt citation, which could result in an Orange County jail sentence. Thank you, sir. You'll be released as to this case.
Thank you.
Joseph White. That's just the order I have him in. Who's that?
We do have Hart next.
Hart.
It's not an arraignment.
Yeah, me too. Mr. White?
Yes, sir.
You're here today because you're arrested on a warrant for failing to appear. There is no bond on that. And I believe that you already had an attorney, a public defender. Is that correct? Yes, you did. Thank you, sir.
We have no bond.
Okay. So that's Ms. Hart? I don't see that one at all. I don't have that in my arraignment.
No, I don't, these aren't the arraignments, Judge.
Oh. Okay. Okay, come on. Oh, there it is. All right. Your name, ma'am?
Jeannie Hart.
All right, Ms. Hart, you're here today because you, is this failed to appear? Yes, you failed to appear on your assault charge. The bond is $5,000, and you already have a public defender in the case. Okay? No. Come forward, sir. Your name?
Sean Davis.
The arraignment docket.
Okay. Sean Davis, we're now on the arraignment docket.
Oh. All right, Ms. Davis, you're here for arraignment on your resisting without violence charge. Say, was there any offer?
Yes, Your Honor. It's an adjudication of guilt, credit time served, no return to 54 West Church Street. There's a cost of investigation of $66 to the Orlando Police Department.
All right, so Mr. Davis, if you wish to enter a plea of no contest, then that would be the offer.
And Your Honor, he would wish to withdraw any previously entered pleas and enter a plea of no contest at this time.
All right, Ms. Davis, are you under the influence of any drugs or alcohol today?
I don't know off the top of my head, so you're going to want to sign here. Let me see if I can check, though, and the judge is going to ask you some
Are you
questions.
under the influence of any drugs or alcohol today?
Not at all, Your Honor.
Have you suffered from or been treated for any mental illness in the past?
No.
Yes or no?
Yes, sir. Yes. You.
Did you take any medication for that?
No, sir.
But you do understand what's going on here today?
Yes.
Okay. You read over your plea form, understood the rights, and signed it on the bottom. Do you have any questions about the rights on that form?
No.
You understand that this is punishable by up to a year in the county jail, up to a $1,000 fine, and that the entry of your plea could result in deportation if you're not a citizen.
Understood.
All right, I will accept your plea. Will judge you guilty of the charge of resisting without violence. You'll be sentenced to 31 days in the Orange County Jail. You do have 31 days credit for the time that you've previously served. I'll impose court costs of $50 cost of prosecution, and you'll have 12 months to get that paid. Actually, and also there was a $66 cost of investigation in the Orlando Police Department. Filing an order that you not return to 54 West Church Street for a period of 1 year. If you do go back there and the court's made aware of that, you are subject to a contempt citation, which could result in an Orange County jail sentence. You'll be released as to this case, sir. Thank you, sir. Wilkember Fernandez.
Your case is resolved. You're good. Good luck with everything.
So you're here for arraignment on your resisting without violence and trespass charges? Is there an offer in the case?
The offer is an adjudication of guilt, credit time served, no return to 709 Brookhaven Drive. There's a cost of investigation of $275 to the Orlando Police Department.
All right, so Mr. Fernand, is that what you want to do, is enter a plea of no contest to that? Yes?
I can hear you.
Yes, sir.
All right. Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
This plea form I've got, you read over that and understood your rights. Do you have any questions about the rights on the form? This form here that you signed, any questions?
No, sir.
You understand that the charge of the resisting is punishable by up to a year in the county jail, up to a $1,000 fine. Trespass is punishable by up to 60 days in jail and up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen. Understand? All right. I do find sufficient factual basis. I will accept your plea. I'll judge you guilty of count 1, sentence 33 days with 33 days credit for time served. Count 2, I judge you guilty, 33 days in the Orange County Jail with 33 days credit for time served. Those sentences will run concurrent with one another. I'll impose a court cost, $50 cost of prosecution, and a $275 cost of investigation to Orlando Police Department. And you'll have 24 months to get that paid. You can pay a little at a time or all at once. Filing an order that you not return to 709 Brookhaven Drive in Orlando, Florida. If you do return to that location within next year and the court's made aware of it, you are subject to a contempt citation which could result in an Orange County jail sentence. You'll be released as to this case. Good luck.
Excuse me, I cannot make that payment.
You got to figure out something. So you got 2 years. So you can pay a little at a time, all at once, whatever you want to do.
Where do I have to go to set that payment, set it up?
You can go to the clerk's office, they'll set up a payment plan for you, or that you can ask them to convert it to community service.
Thank you, sir.
Okay? Jaheem McLean? You are Mr. McLean? Yes, sir. Are you here for arraignment on your trespass charge? Is the offer?
And I was going to say, Your Honor, we'll enter a plea of not guilty at this time.
All right. We'll set that for pretrial in Division 61, and you do have a public defender appointed, so just keep in contact with your lawyer.
Pretrial conference date will be May 5th at 9:30 in courtroom 7C.
Marcus Richardson. Mr. Richardson? Good afternoon. You're here for arraignment on your trespass on property charge.
Offer from the state is an adjudication of guilt, credit time served, no return to the Walmart located at 3101 West Princeton Street. There's a cost of investigation of $50 to Orlando Police Department.
And Your Honor, just from the public defender's standpoint, we did file a motion to withdraw. I'm not sure why the order hasn't gone through. However, we have a conflict in this one, and we'd ask if Your Honor would be willing to allow us to conflict off.
Do you want to wait till after if he wants to plea? I mean, I can just do the plea with him now, and then I can withdraw.
Yes, Your Honor, if
All
you
right.
would like
Mr.
to.
Richardson, did you hear all that? If you want to enter a plea, it'd be time served, adjudication, court costs, cost of prosecution, and $50 cost of investigation. You'd be released today. Do you want to enter a plea of no contest to that?
Yes.
Okay. Are you under the influence of any drugs or alcohol today?
No.
Have you suffered from or been treated for any mental illness in the past?
No.
All right, you understand that by entering this plea, you give up the rights that are on that plea form?
Oh,
That's the right to proceed to trial, the right at the trial to require the state to prove their case beyond a reasonable doubt, the right to question or cross-examine any witnesses that the state would bring to testify against you, the right to bring your own witnesses, finally, the right for you to testify or refuse to testify as provided by the United States and the Florida Constitution. You also have the right to have an attorney present with you at trial, and one would be appointed if you cannot afford it. It sounds like you have one appointed now, but they do have a conflict, and so as a result, we would have to get you someone else if you did want to go to trial. But you're giving up all that if you want to just go ahead and get it over with today and enter that plea to time served.
No.
So you don't want to resolve your case today?
No.
All right, then what I'll do is I'm gonna go ahead and set it for pretrial in Division 61, and I will appoint the RCC to represent him. Is this, so Division, who's 61?
61 will be Judge Star, Judge.
Okay. Because when was that motion filed, do you know?
I believe it was filed on the 16th of March.
Wow. That should have been done by now. I'll get someone to check on that. All right, Mr. Richardson, the public defender's office is gonna be allowed to withdraw, and then a new attorney will be appointed, and they'll be in contact. Okay? Good luck.
No, Your Honor, we don't have the date yet.
Oh, Division 61.
61, that would be, pretrial conference date will be May 5th at 10 a.m. Trial in courtroom 7C.
All right. Romero Robinson?
Yes, Your Honor.
Mr. Robinson, you're here for your violation of probation. The public defender's office is representing you. I assume what you're going to do, we'll enter denial for you.
Yes, Your Honor, we'll enter a denial at this time.
All right, and then we'll set that for a violation of probation status in Division 50.
Case to be heard in Division 50. Status date will be May 15th at 9 a.m. in courtroom 4E.
All righty, thank you, sir. Edward Wallace.
All right, thank you, Your Honor.
Look.
Mr. Wallace, you're here for arraignment on your trespass charge. Is there any offer in that case?
Offer from the state is an adjudication of guilt, credit time served, no return to the Lynx bus station located at 455 North Garland Avenue. Also a cost of investigation of $147.28 to the Orlando Police Department.
All right, Mr. Wallace, you heard all that. Is that what you wish to do? Enter a plea to time served?
Yes, sir.
All right, are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past? All right, you understand what's going on here today?
Yes, sir.
Okay, you read over your plea form, understood the rights. Do you have any questions about the rights for me?
No, sir.
You understand this is punishable by up to a year in the county jail, up to a $1,000 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right. I will accept your plea. I'll judge you guilty of this. You'll be sentenced to 16 days with 16 days credit for time served. I'll impose court costs, a $50 cost of prosecution to the state, $147.28 cost of investigation to the Orlando Police Department, and you'll have 18 months to get that paid, whether you pay a little at a time or all at once. It's up to you as long as it's paid in 18 months. Finally, I'm going to order that you not return to the Lynx bus station at 455 North Garland for a period of 1 year. If you do go back there and the court's made aware of that, you are subject to a contempt citation, which could result in an Orange County jail sentence. All right, you're all set. Thank you, sir. Joshua Williams. Mr. Williams, good afternoon. You're here for arraignment on your resisting an officer without violence, petty theft with a prior conviction, and trespass charge.
Offer from the state is an adjudication of guilt, credit time served, no return to the Walmart located at 8101 South John Young Parkway.
All right, Mr. Williams, is that what you wish to do?
Yes.
All right, are you under the influence of any drugs or alcohol today? Have you suffered from or been treated for any mental illness in the past?
No.
You read over this plea form, understood the rights, and signed it all on the bottom? Any questions about the rights?
No, sorry.
All right, you understand this is punishable by, up by a year in count 1, year in count 2, and 60 days in count 3, and that the entry of your pleas would result in deportation if you're not a citizen.
Okay.
Okay, and what all 3 were filed on?
Yes, Your
Okay.
Honor.
All right.
And I
I
did
will-
advise him that petty theft is an enhanceable offense.
Yes. And it has been, obviously, because it went from a second degree to a first in this case.
Meaning the next one could potentially be a
Might be a felony. Yes. All right, Mr. Williams, I will accept your plea as to count one. Resisting, I will adjudge you guilty, be sentenced to 35 days in the Orange County Jail with 35 days credit for time served. As to count two, petty theft with at least one prior conviction, you'll be sentenced to judge guilty of that, 35 days in the Orange County Jail with 35 days credit for time served. And finally, in count three, the trespass, we'll judge you guilty of that, and you'll be sentenced to 35 days in the Orange County Jail with 35 days credit for time served. Those sentences will run all concurrent with one another. I'll impose court costs and a $50 cost of prosecution to the state. You'll have 12 months to get that paid off, whether you pay it a little at a time or all at once. And then finally, you're not to return to the Walmart at 1801 North John Young Parkway for a period of 1 year. If you do return to that Walmart and the court's made aware that, you are subject to a contempt citation, which could result in an Orange County jail sentence. All righty, you'll be released as of this case. Thank you, sir. Mary, your name, sir?
Need the interpreter? Okay.
It's not Alyssa Malavi. Mario Jean-Jacques? What's your name? That's your name? Okay. All right, sir, you're here today because you're arrested on charge of trespass. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause.
Yes.
Is there an offer in this case?
There is not, Your Honor.
All right. On set in the amount of $500, I'll appoint a public defender to represent you. If you do bond out, you're not to return to the alleged scene in this case, which is
Disney.
Walt Disney World, any
Your Honor,
Walt Disney World property.
I don't know if we should have an interpreter. Mr. Jean-Jacques usually does have a Creole interpreter. I just wanted the court to be aware that usually we do have an interpreter for him.
Do you need an interpreter?
No.
Okay.
Okay, I just wanted to make sure
Sure,
that he was
no.
aware of the option and the court was aware as well. I apologize, so the bond is still at 500?
Yeah, I'll leave it at 500. I'll take no action on the other ones because they're
Thank you.
recent, but
Your Honor, you understand that the out on bonds are for trespass for the exact same place?
one of them was just like a week ago, and he said he was going back for his car. The other one, I guess, was older. It was like, what, December?
And to be fair, his vehicle allegedly was there, so
was-
it makes
but it was
sense to go
towed.
back to the place.
That's not there anymore. It's towed. So don't go back to Disney at all. If you bond out, you're not allowed to go back to Disney. If you go back to Disney, you'll be a no bond on all of them.
So if you
Promise,
Turn back
okay?
to Disney, all of these cases are gonna hold you no bond. So no more going back, right? Okay, good luck.
Because if that happens, she's gonna come to my office and make me sign the order. Ronald Pratt. I'm Mr. Pratt. You're here today because you're arrested on a charge of trespass. I've read the charging affidavit. I do find that there is sufficient probable cause. Is there an offer in his case?
You went over this.
Offer from the state is an adjudication of guilt, credit time served, no return to Fortis at Park Lake, located at 307 Park Lake Circle.
Is that what you wanted to do today?
And Mr. Pratt, did you want to enter a plea today and resolve your case?
Yes, sir.
All right. Are you under the influence of any drugs or alcohol?
Yes, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes, sir.
You read over your plea form, understood the rights and signed it. Do you have any questions about those rights?
Yes, sir.
You understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
Okay, go ahead and sign it. All right, we'll accept your plea. We'll judge you guilty, be sentenced to time served, the court costs imposed, and a $50 cost of prosecution. You have 12 months to get that paid off. And finally, we'll order that you not return to 307 Park Lake Circle for a period of 1 year. If you do go back there and the court is made aware that you are subject to a contempt citation, which could result in this of a Orange County jail sentence. All right, we release as to this case.
Good luck, Mr. Pratt. Good luck. Yes.
Tina Roberts.
Yes, sir.
All right, Ms. Roberts, you're here today because you were arrested on charge of trespass.
I can't hear, sir.
All right, you're here today because you were arrested on a charge of trespass.
No, I can hear you, sir.
All right.
Your Honor.
And I did read the charging affidavit. I do find there's sufficient probable cause. Is there an offer in Ms. Roberts' case?
Offer from the state is an adjudication of guilt, credit time served, no return to Wekiva Riverwalk Shopping Center.
Would you like to take that off first?
Yes, sir. Yes, Your Honor.
Is that what you wish to do? All right, are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
They have it wrong. I was diagnosed with post-traumatic stress disorder.
Okay, but you
That's
understand
it.
what's happening here today?
Yes, sir.
You know what this charge is about? Yes?
Yeah, it's I thought when they trespass you, they have to do a paper on you and then you sign it. Like I was there trying to get work.
That's one way to do it, but you've been told that you're not supposed to be back there by someone who has the ability to tell you that, in the sense of they have control of that property.
Yes, sir.
So regardless of whether you've got a piece of paper or not, you're not supposed to go back there, okay?
Yes, sir.
And I'm going to order that you not go back there if you do resolve it today.
Yes, sir.
Okay. You read over a plea form, understood the rights, and signed it. Do you have any question about the rights on those forms?
What?
The rights you're giving up on the form?
Before. Any questions?
No, sir.
All right, you understand this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen.
Yes, sir.
All right, I will accept your plea. I'll judge you guilty. I'll sentence you the time that you've served. I'll impose court costs and a $50 cost of prosecution. You'll have a year to get that paid off. And then finally, I'm going to order that you not return to Wekiva Riverwalk for a period of 1 year. If you do go back there and the court's made aware of it, you are subject to a contempt citation and could be sentenced to the Orange County Jail.
Thank you, Your
You'll be
Honor.
released as to this case. All right, you need to sign that, yeah.
Good luck with everything.
All righty. Roy D. Robinson.
Yes.
Mr. Robinson, you're here today because you were arrested for the charges of providing false identification to a law enforcement officer and for open container. Is there an offer in that case?
Sorry, offer from the state is a withhold of adjudication, credit time served, and no return to the Mattress One located at, I can't see, 2900 East Colonial Drive.
All right, if we wish to enter a plea, it would be a withhold of adjudication, time served, and court costs, and then a requirement that you not go back to the Mattress One. Is that what you wish to do?
Yes, sir.
All right, are you under the influence of any drugs or alcohol today?
No.
Have you suffered from or been treated for any mental illness in the past?
No.
All right, you understood the rights on that form. Do you have any questions about anything on that form? The form that you just signed, any questions about it?
No, sir.
You understand that these are both punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen? Yes? Understand that?
Yes, sir.
All right. I will accept your plea. I'll withhold adjudication as to count 1, false identification. You'll be sentenced to time served. As to count 2, I'll withhold adjudication. Those sentences run concurrent with each one another. And I'll impose court costs and a $50 cost of prosecution. Yeah, I guess it's on the one. Is this 2 case numbers? No, okay. And I'll order that you not return to the Mattress One at 2900 East Colonial Drive for a period of 1 year. If you do return there, you are subject to a contempt citation. You'll be released as to this case. Thank you. All right, we did Ms. Hart. Elijah Lofton.
Hello.
All right, just a second, Mr. Lofton. All right, Mr. Lofton, you're here today because you're arrested for a number of charges. This is based off a probable cause warrant that was signed by a judge previous. Hold on. In 2023 2016, it's petty theft charge. Bond is set in the amount of $500. Actually, it's $250. I'll appoint a public defender to represent you on that one.
And Your Honor, you said $500 for this case?
No, it's $250 on that one, actually. I didn't.
$250. I know there was other cases, but I believe we're only here for 2023 MM00.
Yeah, so the other ones we're not here on yet? Or did we already see him?
Oh, I thought we were only here on 2617.
Yeah.
Oh, we are on 2617. Let me see, hang on just a second. All right, that's also a petty theft, so 2617, that's petty theft of $100 or more, it's $250. And I'll appoint a public defender, and if you do bond out, you're not to return to the scene. So all these, the 2023, the CFs, 1796 and 9455, we don't have those today. All right.
That, I can't fully review it with you, but you still have no bond on another case, okay? So your attorney will be able to talk to you in more detail, but that's just so you have an idea of what that one's about, okay? I think it was just that one. Yeah, I mean, you have other cases, but that's the only thing we are here for today. No, just that one. Just, that's it for today. Everything else you already saw the judge for that we're aware of, okay?
There's no bond on this one?
You have no bond on the one you were here previously to talk to the judge, and then you get $250 on this case, the new case, okay?
All right, Joshua Pope. All right. I'll appoint a public defender if he doesn't have one from the previous case, and stay the bond, it's none.
500?
Is it 500 on the failure to appear? Yeah, 500.
Yes, Your Honor, it's at
All
500.
right.
If we can stay the bond.
Yeah, we will.
500. Thank you.
Andrew Hutton.
Here I am, Your Honor.
Alrighty. Mr. Hutton, you're here today because you're arrested for a charge of open container. I reviewed the charging affidavit. I do find there's sufficient probable cause. Is there an offer for the city?
It's an adjudication and credit time served.
All right. If we enter a plea, it would be an adjudication of guilt, time served. Is that what you wish to do?
Yes, sir.
All right. Go ahead and sign your plea form. Are you under the influence of any drugs or alcohol today?
Yes. I am coming down off marijuana.
Okay.
Drug.
Have you suffered from or been treated for any mental illness in the past?
Yes.
Take any medication for that?
Yes.
All right. And you understand what's going on here today? You understand what this charge is about?
Yes, sir.
You understand that this is punishable by up to 60 days in jail, up to a $500 fine? Yes?
Really?
That's not what you're getting. That's what the potential penalty is, though. You understand?
Yes, Your Honor.
You understood all the rights in this and then signed it on the bottom?
Yes, I
All right.
did.
I will accept your plea. I'll judge you guilty. You sentence to the time that you've served. I'll impose court costs, $223, and I'll give you 12 months to get that paid off.
All right,
You'll
thank
be
you.
released as to this case.
All right. Thank you.
Good luck.
Juwan Nance. Does he have an offer you might want to take?
Your Honor, there is a credit time served offer.
Yeah,
If we can
reset it for
reset it.
tomorrow?
Yes, Your Honor.
All right, let's reset him for tomorrow. Nicholas Brown.
What are you doing?
Mr. Brown,
Yes, sir.
you're here today because you're arrested on a charge of possession of cocaine. I do find sufficient probable cause. A bond set in the amount of $1,000. I will appoint a public defender to represent you. If you do bond out, do not possess any guns, weapons, drugs, or alcohol.
Yes, sir.
You're all set.
Take this with you?
Are we not doing the traffic?
That was 1,000.
They bonded.
Hold on.
All of them?
Hold on,
Okay.
let's go back.
Both of them, I should say?
Nicholas Brown.
Nicholas Brown.
That was
felony.
him.
I asked him if that was him, right?
Oh, the
Okay.
it does, I do believe the traffic's bonded James Chambers and Erica Nichols.
That was Nicholas Brown, and that's Dave.
Yeah, 1,000.
Okay.
But thank you, because I'd rather check that than assume.
Juwan Nance? What happened with Juwan Nance? Was that the refuse?
That was we're bringing back tomorrow, right?
Yes.
Yeah.
Juwan Nance is reset for tomorrow.
Okay.
And then Chambers and Nichols bonded.
Okay, David Descent. All right, Mr. Descent, you're here today because you were arrested for 3 charges. I have reviewed the charging affidavit. I do find that there is sufficient probable cause. As to destruction of evidence, bond set in the amount of $1,000, possession of methamphetamine, $150, and possession of drug paraphernalia, $100. I'll appoint a public defender to represent you. And if you do bond out, you're not to possess or use any guns, weapons, drugs, or alcohol.
Good luck with everything.
Sebastian Daciel, Vero Rodriguez, Sir, you're here today because you're arrested on a charge of carrying concealed firearm. I do find that there is sufficient probable cause. I could set a bond, or you are eligible for pretrial release. If you want to do that, that wouldn't require a monetary bond, but there are conditions that go along with that. If you're on pretrial release, you have to check in with an officer from time to time. They'll probably drug test you, but you don't have to post any bond or any money. Otherwise, the bond would be $2,500. Which one do you want?
That just depends resolving. This is just for your release. Right? What actually happens with the case down the line hasn't been decided. It's just regarding your bond. Okay. Your Honor, he'd like to do the pretrial release.
All right, well, I'll release you with pretrial conditions. If you're not to possess any guns, drugs, weapons, or alcohol, I'll appoint a public defender to represent you. So stay in contact with your attorney.
Once you get released, so you're gonna have 2 people.
Shanita Gatlin.
And R.
All right. Appoint a public defender for Ms. Gatlin.
I apologize. What happened to Winnie Exum?
Yes, Judge.
Thank you.
And I apologize.
I don't know.
Right.
I just have a stack of papers. I'm just reading the names. I'm not.
And have we done Shanita Gatlin yet?
No, that's who we're on now. She's outside medical. What happened with Exum?
Yes. When
Bonded.
he bonded, oh, thank you.
Well, somehow you must have known that because you took it out of my stack.
I didn't take it out.
I didn't have it.
Oh,
See, you were predicting it.
yes.
Gatlin is outside medical. I have.
For Gatlin, there is one probable cause argument.
All right, on which one?
For the possession of a prescription drug without a script, they don't.
I agree.
Yeah, no objection, Your Honor.
All right. I'll set bonds in of the following: $1,000 on count 1, ROR on the prescription, 100 on the resisting, and 100 on the paraphernalia. Point a public defender.
Thank you, and we'll waive.
No guns, no drugs, no weapons, no alcohol. Brent Goble?
Sir.
All right. Mr. Goble, you're here today because you're arrested on several charges. First of all, providing false identification and possession or creating a fictitious personal ID. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. The bonds are $1,000 on the creating or possessing the fictitious personal ID and $100 on the false identification. I will appoint a public defender to represent you. I know that you're from out of town. You would be allowed to leave. I wouldn't have a problem with that, but you have to keep in contact with whoever your surety is and your attorney. Okay?
So make sure you call our office when you bond out. Stay in touch with us so we can let you know what happens with the case, if charges are filed on or anything like that.
Okay.
You're gonna have to talk to your attorney about a bond motion. I'm assuming he's not gonna release you ROR because you're out of state. Anymore, I see. Good luck.
Anna Hammett? Come on up. All right, ma'am, you're here for 2 different cases. In the 4983 case, you're here for a grand theft motor vehicle. I have reviewed the charging affidavit. I do find there's sufficient probable cause, and the bond on that is $1,000.
So,
You do bond out, and I'll appoint a public defender, no guns, no drugs, no weapons, no alcohol. And in the second count, there's a possession of MDMA and a possession of drug paraphernalia. That's the second case, 4984. This is the case number on that. And I do find that there is sufficient probable cause on that as well, and I'll stay those bonds at as they were before. $1,000 count one, $500 count two. And appoint a public defender on that as well. And then has this case been filed on? Probably not, huh?
No, Your Honor. She
January?
was arrested January 6th. Formal charges have not been filed yet.
I'll take no action on that then.
Sir, can I ask you a question?
Yep.
I don't have any money. I have 7 kids. And I wasn't even driving the car that the officers was talking about. I
Just
pulled
watch
up.
what you're saying.
Well, that's not their allegation. The allegation is that you were driving it earlier.
I wasn't
watch
though,
what you're
sir.
Well, I understand that, but the charging affidavit says that you were driving it, that they found the car later, you came up and then took items out of the car,
Say anything. 'Cause you'll-
out of the stolen car. And actually, you're not even really required to drive it to be charged with it. You could be around it or in possession of something that's recently stolen without a good excuse, so. I understand that. You have a public defender, they can certainly should try to get a different form of release, but you're not eligible for pretrial release at this point. So I can't do anything.
Your bond.
Yeah, and then also no action on the new case, on the old case. Dennis Hayes. All right, Mr. Hayes, you're here today because you failed to appear. You're arrested on the failed to appear warrant. What's the bond on that?
None.
Yeah, there's no bond on that, and I think you already had a public defender. Does he? Did he already have a lawyer? If not, I'll appoint a public defender.
Thank you, Your Honor. And take this with you. Talk to our office about the no bond, okay? Good luck.
Keisha Jackson. Are you here today because you're arrested on a charge of criminal mischief and burglary to an occupied dwelling? I have reviewed the charging affidavit. The bond on the burglary is $5,000. The criminal mischief, $150. I'll appoint a public defender to represent you. If you do bond out, you are not to possess any guns, drugs, weapons, or alcohol, and you're not to return to the address of 45 West 10th Street. And as I said, a public defender will be appointed to represent you.
Did you also say no contact, Your Honor?
Okay, no contact with,
Hold on one second.
does it have a name? I thought
There's
this
a
might
They
have
don't
been-
provide a name, Your
I
Honor.
want you to hear it.
Yeah, okay, just no contact with the alleged victim.
Thank you.
The owner of the RV. Aaron Lofton?
I was in court yesterday, sir, all day, and it was raining, and I hit the wrong button and went to the wrong floor. That's why I'm still dressed up, as you see. I was
Okay.
in court.
Well, you're here today because you failed to appear on your robbery case, and there is no bond on the warrant for failing to appear on both of those counts.
Yes, but I was in court yesterday on both of those in trial yesterday, and it was raining, and I went to the wrong floor. And when they arrested me, I was on the 9th floor, sir.
Okay, well, the failure to appear that this warrant is for is from,
From yesterday, because I was in court for both of them, sir. I've been out of bond about a year and something. I haven't done nothing wrong, anything. I haven't done anything wrong, sir. I was in court all day yesterday, and it was raining, and I messed around and got on the wrong.
well, you'll have to talk to Judge Harris about that. I appoint a public, you already have the public defender? No.
I have public.
You have RCC. You got Adam Lewinson already on your case.
'Cause I didn't want to stay in jail. I take care of an old lady, sir, and she's on hospice, and she's on hospice.
Well, I understand. There's nothing I can do about this bond. That was set by the judge. That judge, it's her case. So you'll have to get, your attorney will be in contact, and they'll take care of it. All right. Thanks.
So when I do the court, can you at least tell me how long I got to sit in jail, sir? Because I was in court all day yesterday.
It's up to Judge Davis. So I don't know how long that'll be. If your attorney can get to Judge Davis tomorrow, it could be tomorrow. If it takes a week, it'll be a week. I don't know, unfortunately. I don't know how long it'll take. I don't know. I don't know. Michael McDonald.
Yes, sir.
All right, Mr. McDonald, you're here today because you're arrested for 3 charges.
Can you hear?
I'm not
Uttering a forged check.
Your Honor, if we can have a moment to get the hearing assistance, as he's partially hearing impaired. Can we get him?
Yes, please.
Sorry, Your Honor, I didn't mean to interrupt.
All right. Can you hear better?
Oh, yes.
All righty. Well, you're here today because you're arrested on 3 charges: uttering a forged check, possession of counterfeit payment instrument, and defrauding a financial institution. I have read the charging affidavit. I do find there's sufficient probable cause. Your bond is stayed at $4,000 on the uttering a forged check, possession of counterfeit payment instrument, and the defrauding a financial institution. Those bonds are $300 apiece, and I am appointing a public defender to represent you.
Good luck with everything. Our office will be.
Your Honor,
Good luck with
I would ask that he not return.
No return to Seacoast.
Thank you.
All right. And also, Mr. McDonald, you're not to go back to the Seacoast Bank. Don't go back to that bank.
I won't.
Okay.
Good luck.
Andy Mateo?
Yes, sir.
All right, Mr. Mateo, you're here. All right. First of all, from a probable cause warrant signed by a judge, and that warrant found probable cause for the following things: possession of cocaine with intent to sell and deliver, bond set at $10,000; possession of methamphetamine with intent, $250; possession of ammunition by a convicted felon, $250; possession of cannabis, $150; and possession of drug paraphernalia, $150. I will appoint a public defender to represent you on those charges. For one case, and that was the 2023 CF 4054 AO. You also have 2023 CF 4992 AO. That's a arrest case. It's not from the affidavit, a warrant, but there was in the charging affidavit. We do find sufficient probable cause for a charge of possession of cocaine with intent to sell or deliver with a weapon. Bond set at $15,000. Possession of methamphetamine with a weapon, $150. Possession of firearm by a convicted felon, $150. And possession of ammunition by a convicted felon, $150. And appoint a public defender on all of those cases as well, for those charges. If you do bond out, you're not to possess any guns, drugs, weapons, or alcohol. And it looks like that's it. Thank you, sir. Terry Perry?
Yes, sir.
All right, Mr. Perry. You're here today. You're arrested on charges of grand theft, dealing in stolen property, and receiving money from a pawnbroker by false verification. Bonds on those are $1,500 on the grand theft, $150 on count 2, dealing in stolen property, and count 3, receiving money from a pawnbroker.
Your Honor?
Yep.
An information was filed, and they only went forward on the dealing in stolen property and petty theft. They did not file on the receiving money from a pawnbroker.
All right, so the grand theft then, I'll reduce the bond on count 1 then, which now that they filed it as a petty theft, to $500, and the dealing in stolen property of $150, and then there isn't a bond. Do I need to say something? Because
ROR.
I'm on that, because that, and appoint a public defender to represent you on that as well.
So the total bond is $650?
Yes.
Okay.
And you're not to return to,
Only on one count. It's your history.
you know where it was?
I think it was a laptop that was stolen from an
Oh, wait.
individual,
All right.
is the
No
allegation.
contact with any witnesses and no return to the scene.
You don't qualify because you do have the possibility to appear. You're right, it was just filed and it's been a while since they had it. Look.
Okay. Rochelle Reece, is that right?
Yes, sir.
Who is this?
It's just a failure to appear.
Rochelle Reece.
I don't have her.
It's right after Terry.
What's the bond on the failure to appear? It's just a failure to appear, right?
Yeah.
All right, you're here because you failed to appear on your felony case. There is no bond on that. And I believe you already have an attorney on that.
And Your Honor, just in case there's no public defender, if we can just for the
I'll
record.
appoint a public defender if one was not previously appointed.
All right, so contact your attorney and you'll be able to talk in more detail. It's no bond, it's an meeting, another judge did it, so he's not going to change it today. So you're going to have to get in front of the judge who has the case to do anything, okay? Good luck with everything.
Your name, ma'am? Ashley Ravel?
Ashley Ravel.
All right, Ms. Ravel, you're here because you're arrested on a charge of uttering a forged bill and petty theft. I have reviewed the charging affidavit. I do find there's sufficient probable cause. State bonds of $1,000 on the uttering the forged bill and $500 on the petty theft, and I'll appoint a public defender to represent you.
I'm sorry, how much on the petty theft?
500?
Oh, you left it as is, okay.
Yeah, it was 1,500.
And Your Honor, there is a probable cause argument for this one.
All right, I'm Mr. Roberts.
Yes, Your Honor.
Okay, Mr. Roberts, you're here today because you're arrested on a charge of, I've never seen it out like this, the way they wrote it out, but do they intend it to be just a petty theft
With two priors.
with priors?
Yes, sure.
Yeah, okay, all right. All right, what did you want to argue?
Your Honor, defense was going to argue, first of all, as the court has been made aware, the charge it came in under, there's no probable cause to support that. That charge requires multiple thefts within a specified period of time. If the court is inclined to find probable cause for petty theft, defense has no objection to that. However, defense would be objecting to the felony petty theft, as all that is mentioned is that he has 25 prior convictions. It doesn't say of what, it doesn't say petty theft convictions. Just literally 25 prior convictions, which I don't think is clear on whether they were theft or other convictions.
Agreed, Your Honor, and if I could have 24 hours to clarify that?
Okay, you can come back tomorrow. The bond will be stayed at the, what is it, 1,500 currently?
It's 2,500.
Or is it
right now.
2,500? I will stay at 2,500, and then we'll give them 24 hours. If you don't bond out when they come back tomorrow, then it'll just, probably just find probable cause as a petty theft. Okay? And you do have a public defender appointed, though, from now on.
The case goes away. Okay? Good luck.
Mr. Silvera? Is that right? All right. You're here because you're arrested on charge of possession of cocaine and petty theft of $100 or more. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. The bond on the possession of cocaine is $1,000. The petty theft is $500. If you do bond out, no guns, no weapons, no drugs, no alcohol, and don't return to
Macy's.
Macy's. Okay? All righty.
Stay in touch with us, okay? Good luck.
Ray Stiles.
Yes, sir.
All right, Mr. Stiles. Mr. Stiles, you're here because you were arrested on charge of driving while license suspended. Bond is set in the amount of, I'm going to reduce that bond to $500. And then out on bond.
Your Honor, in 23 CF 291, formal charges have been filed. Pretrial is set for June 14th. On 23 CT 432, formal charges have been filed. Pretrial is set for April 19th. In 23 CF 289, defendant was arrested January 28th. Formal charges have not been filed yet.
Okay, so no action on the first, on that one too. That's the first one on my list. And then in the 1432, that's a driving license suspend. I'll revoke that bond, new bond, $1,500. And on the unlawful possession of a stolen or debit card, what is that? $1,500. Revoke that new bond, $3,000. Appoint a public defender to represent you on your driving while suspended charge. Which one?
20, driving while suspended.
Yes.
And then the out of county.
Oh, no, on the new one, I reduced that one to 500. But out of counties, the first one, the 289, I think it was, that's not filed on, so no action. And then the next two I just revoked and doubled.
And what was, I'm sorry, 2023 CF 7.
I want to hear.
Revoked, and what was the bond amount?
767, I don't see that one. I've got two.
I just want to make sure I have the right amounts too.
Oh, I see. Okay, yeah, that's the jail number, 767. I think, yeah.
Can you go over them again?
Okay, all right. So I'll go back through them each one by one. All right. In the new case, I reduced it to 500. In this case, the possession of cocaine, that one is not filed on, so there's no action. And that's in CF 4983. 4983. That's the first one that's on Odyssey.
I don't even see.
Then there is 4985.
4985 is the one we're here for today, correct, Your Honor? And that's the $500 bond?
Well, that says he's out on bond.
That's the one we're here for today, Your Honor, 4895.
Oh, I see. Okay, no, then I'm reading the wrong number. Hang on.
4985.
Want me to help you out, Judge? It's
Please.
Yeah, no, well, I'm just trying, what's the case number on that one?
on which one?
The Dwellis that he's out on bond on from Osceola.
23 CT 432.
432. You have that one. That's a Dwellis from Osceola County. That one's now $1,000, revoke and double.
You
Okay.
doubled it to 1,500, Your Honor. That's what I have down. You doubled it to 1,500. If it's supposed to be 1,000, I'll write that.
Oh, I am a lawyer, so yeah, just make it 1,000 because I doubled it. My multiplication skills are not very good, I guess. And then the last one went from 1,500 to 3,000.
That is
23 CF 291.
291.
Right,
And no action on 289.
right. Mhm. And then we've got the motion, and now that I have the motion, I'll grant the motion, state's
Oh,
motion.
Your Honor, if we can, is that the 40-day motion, if I
Yeah.
can be heard in just a moment?
Well, technically, I don't think it's ready in tomorrow anyways, but go ahead, I'll wait.
Thank you, Your Honor. So 500, 1,000, 3,000, they revoked and doubled these bonds. Those were your out on bonds. When you're out on no bond. Some judges will do that, okay?
Devon Williams and Jonathan Williams.
Jonathan Williams bonded.
Jonathan Williams bonded, thank you. And Troy Devon Williams.
Your number, MA number.
His bond number, his MA number is 23009-763. He bonded, let me see.
And Troy Williams?
And Troy Williams, yes. He bonded, thank you.
Somehow you knew that again, I didn't have that one. I'm out of sheets. So. Okay.
Your Honor, this is regarding the 40-day motion. Just to get the case on the record, it's State of Florida versus Gregory Jr. Woodfolk, case number 2023 CF 5. Defense is objecting to state's requests to extend the 33 days into 40 days. First of all, defense was not properly noticed of this hearing. My counterpart just found out this morning, nothing was filed with us, and we were not aware of it. So we would argue, one, that we were not properly noticed of this hearing. Due process requires that notice be reasonably calculated under all circumstances to apprise interested parties of the pendency of the action and afford them the opportunity to present their objections. Furthermore, the state claims that they have good cause for asking for this extension. However, defense would argue against that. The state has had ample enough time to have FDLE test the alleged substances. Additionally, there is no evidence besides the state attorney's own motion showing that there has been any backlog with FDLE in Orange County. Oftentimes, the state
I think most people know that, like, just intrinsically, that work in the system on a regular basis, that it is backlog. There's no doubt about that.
Understood, Your Honor. However, additionally, the state does not need to wait until FDLE results are back to file charges. That is a policy of their office. It is not a requirement. Therefore, they do not need these results to file formal charges. And for those reasons, one, no evidence has been presented. I understand the court's reasoning and logic, but no evidence has been presented besides what has been stated. And we would argue that there's no good cause for this extension. They've had ample time. There are times where they are able to get these substances tested much quicker, and they have chosen not to.
Response?
Your Honor, this is the 4th time that defense has made this argument with the 4th judge in the 4th month, and every time it has found to be good cause. As the court has noted, it has been established that there is a backlog at FDLE. In the motion, it states there is a backlog at FDLE and that the ASA has spoken to the supervisor and indicated that it will be filed by the 40th day, that the results will be back by the 40th day. In addition, if defense is going to argue that they haven't received notice, the 33rd day is not until tomorrow. We can argue this tomorrow.
That's what I was going to say, is I could just roll till tomorrow, give them an opportunity if they want to try to argue something else. But I'm inclined to grant it just because I know what the backlog is. And Mr. Woodfolk is not being held on an onerous bond. I think his bond is like $5,000 as I think when I thought I looked at it. So that's not like he's under $100,000 or it's almost impossible. He could, if not that he's required to, but he certainly, I think, potentially could. And I don't know if there was ever an attempt to get him released or get the bond reduced in any way, or there's any allegation that he can't afford that.
Your Honor, the bond's at, you said 50,000, correct? Because that's what I'm seeing.
Yes, Your Honor, it is 50,000.
Not 5,000.
I'll wait till tomorrow if you want me to do that, and then, because tomorrow's the 33rd day officially, so if you want to come up with something, if you want to argue more tomorrow, we can do that. It's fine by me.
Understood, Your Honor.
Okay. I'll just leave it right here.
Is that what defense is asking for, is for this to be rolled?
I mean, at this time, defense is objecting at this time, so.
We'll do it with our stack tomorrow. Okay.
That was Woodfolk.
Woodfolk, yeah. Alrighty. Here's all of your sheets. It'll be like this tomorrow. Well, it won't be like it was Monday. Not at least this week.
The weekend didn't want to deal with it.
I know, I love her accent. Idris Elba. Rebecca, we were talking about her accent, Miss Eugene. Read your emails for me when you get a chance. Read your emails for me when you get a chance. Oh, I sent another. Okay, thank you. Okay. What? Oh, yeah. I didn't know, they didn't call these. I just want to make sure they called it. Oh, yeah. Oh, that's what you're saying, yeah.
Hey guys, thanks for watching Bond Court. I would really appreciate it if you hit the like button and subscribe to my channel. Bond Court is now in session.
No bond on that. And we'll appoint a public defender to represent you on your violation of probation. It'll be set for a violation of probation status hearing at some point. And that's 2021 CT 253AO. Thank you, ma'am.
Thank you.
All right, is that it for Spanish? All right, thank you, sir.
You're very welcome. Have a good day, Your Honor.
You too. Your name, sir?
Paul Thorne.
Oh, okay, we're gonna. He's Paul Thornton. Yeah, just a second, Mr. Thornton. Madam Interpreter, are you there?
Yes.
All righty, have you been sworn today?
No, not yet.
It's really.
Raise your right hand. Do you solemnly swear to translate from Haitian Creole to English, from English to Haitian Creole in the testimony given today?
I do. I can barely hear you, Your Honor. I'm sorry.
I'm sorry. State your name for the record
Francisca,
and your ID number, please.
250881.
All right, thank you. Our defendant is present. Please state your name, sir.
Vous répétez non, monsieur?
Stevenson Richard.
Stevenson Richard.
All right, sir, you're here today because you were arrested on 3 charges: battery by strangulation, domestic violence, battery, domestic violence, and obstructing justice or hindering communication with law enforcement.
Je dis à ou là parce que ou pas bagay pour 3 charges, je arrête pour 3 charges parce que ou t'a goumé avec parce que ou t'a essayé étrangler un monde pour goumé assurer parce que qui gagne violence et pour goumé parce que t'a utilisé mot pour jouer contre autorité.
I have reviewed the charging affidavit, and I do find there's sufficient probable cause.
Ou capable avec charge ça yo joindre que que suffisamment de raisons pour ça.
Were you living at the South Kirkman Road apartment?
Est-ce que vous t'es habité dans l'appartement qui est dans South Kirkman Road là?
Oui, c'est moi avec madame Matoua Timon.
Yes, between me, my wife, and our 3 children.
Okay. Do you have another place to go and live if you bond out?
Si vous avez un monde qui paye un bon pour sortir, est-ce que vous avez l'autre côté pour arrêter?
Oui, moi j'ai un peu de famille. Je vais parler avec eux pour moi.
Yes, I do have a lot of family members that can help me.
Okay. You're eligible for pretrial release, which doesn't require a monetary bond if you want to do that. Or I will set a bond on each of the charges. But if you want to do pretrial release, that wouldn't require a bond. You just have to keep in contact with your pretrial release officer. Would you rather have that than a bond?
Yo capable laguer ou avant procès sans pas gagner pour payer un goût ça. Mais seulement gagner pour rester en contact avec officier relâche avant procès. Est-ce que vous voulez laguer comme ça gratis ou bien est-ce que vous voulez payer l'argent pour laguer pour chaque charge?
Vous pouvez répondre moi s'il te plaît.
I'm going to repeat. Yo capable laguer ou en bas comme si pré-procès, son pas gagné pour payer $1, mais seulement ou gagné pour kembe contact avec officier relâchement. Ou bien, yo capable laguer ou pour faut payer l'argent pour ça avant même que vous venez dans procès.
Pour travail, moi,
Qui sont voulez faire?
pour travail, moi, mal travail. Par contre, combien de bon, yo dis, par contre, combien de bon n'a côté.
I have to go back to work, and I don't know how much the bond will be.
Well, if you want to go, if you don't want to have to post a bond, then you can go with pretrial release. There won't be any money that it will be required.
Si ou pas obligé de poster un l'argent bon, ou pas gen l'argent pour payer, ou après ou relâche sans avant procès, li pas gen l'argent, li gratis.
Okay?
Pas un problème. On va ça si m'a besoin comme ça m'a pour m'a contact avec policier.
Okay, no problem. If it's possible, I will take it. I will keep contact.
All right, I'll release you through pretrial release. You're not to possess any guns or drugs, no weapons, no alcohol. You're not to have any contact with Normanjo Louise Charles, and you're not to return to 1089 South Kirkman Road, Apartment 204. You can go there one time with law enforcement to pick up any personal items you may have.
Pendant yo ap lage ou avant procès à comme ça sous condition ça, ou pas supposé posséder ni armes, ni drogue, ni aucune arme blanche, ni alcool, et ou pas supposé entrer en contact avec ni l'amant Jean-Louis Charles, ou pas supposé aller dans adresse 1089 dans South Kirkman, numéro appartement 204, ou seulement capable aller ça une seule fois avec un officier qui a accompagné pour aller prendre effet personnel.
Okay, and I'll appoint a public defender to represent you.
Your Honor, DCF should have been contacted
Yeah,
regarding
if
this.
DC, and also if the Department of Children and Families get involved because there are kids between the two of you, you need to follow any order or agreement they put in place.
Et puis tout, si que département Timoun ak famille t'est involved à cause de Timoun yo, faut qu'on suive quelle que soit la direction, ça ou dû faire pour suivre ensemble avec yo.
OK, on a une question, combien toi Timon et si m'a bail au comment et sous transfert tout fait sous banque là pour me bailler pour me payer. Qui ça moi faire pour ça?
I have a question because I have the 3 children to taking care of. How do I contact her if I want to give money from my bank account to her?
Well, if you have family members, you can get the money to them and then they can take it to her, but you can't have contact.
Si ou gen famille, ou capable bay famille ou l'argent pour bay pour Timoun yo, ben ou bay Timoun yo, mais ou même ou pas supposé entrer en contact du tout.
Et moi pas ka Timon yo tout.
So I won't be able to see my children either?
Not right now, unless they can work something out where you won't see have any contact with your wife. Now, she can let the court know that she has no objection to having contact with you, and that could be changed later. But for right now, unless someone else from your family can pick up the children, and you can see them that way. But if DCF gets involved, you got to follow what they say.
Pour kounya, non. À moins que madame ou l'état fait connaître que li pa gen aucune objection contre ou même pour ta wè timoun yo, et puis tous à moins que ta gen yon famille ou qui capable al prendre timoun yo ou capable wè timoun yo côté famille ça bien. Sinon, c'est département timoun ak famille, quel que soit ça yo déterminé, c'est lui même poursuivre, mais c'est pour kounya.
Oui, m'accepte. Ça veut dire m'ka jwenn yon, ça veut dire est-ce qu'il a fait le connaît pour lui même les moun n'a vinn derrière Timon yo si la bail ça me dit.
I can have a family member pick up the children so I can see them at the family member's house, as long as she agrees, if she's okay leaving the children to that family members of mine to bring it to me to see them.
That's a completely separate issue. That's not anything I can get involved in. You just need to not have any contact with your wife, okay? All right. Upon a public defender, stay in contact with your lawyer. Go ahead.
Ça c'est un bagay qui complètement différent que moi-même pas qu'à résoudre. Ça c'est un bagay qui est capable d'employer avocat avec lui-même qui va le connaître qui ça pour faire pour défendre. Moi-même pas qu'à doit partir ça.
OK, merci un peu. Merci beaucoup.
All right, thank
you very much.
All right, your name, sir?
Paul Thorne.
Mr. Thornton, you're here today because you're arrested on a violation of probation charge. There's no bond on that. And I will appoint a public defender to represent you on that violation.
Yes, sir.
Thank you.
This is the interpreter. Is my
Oh,
help
yes, thank you,
needed,
ma'am. I'm
officer?
sorry. You're all set. Did you need a case number or no?
No, they already have it. Thank you for
All
using
right.
our services.
You're
Have
all
a great
set.
day. Bye-bye.
Appreciate it. Bye-bye. Bakiba Thomas? All right. All righty. We tried. I'll set bond, or stay the bonds in the case. Appoint a public defender to represent him. Okay. Your name, sir?
Ravi Iyer, Your Honor.
All right, Mr. Iyer, you're here today because you're arrested for contempt of court, violating a no-contact order out of Broward County, and battery domestic violence. I have read the charging affidavit, and I do find there is sufficient probable cause. Do you guys live here?
Yes, Your Honor.
All right. And do you have another place to go other than the home or apartment that you share? Is that at Penhurst Lane?
Yes, sir.
You have another place to go?
Yes, I have a uncle that lives by Lake Mary.
All right. I don't know what they want me to do out of Broward County.
I think it's, isn't it Brevard?
Is it Brevard? I thought it was Broward. What? Oh, it's Brevard, you're right.
I think it's just a contempt of court, Your Honor, so, and it happened here because they were here.
Right. Yeah.
So.
All right, I'll just.
Considering, but as you set bond, I would like you to note that there have been at least 3 other incidents of domestic violence with the same victim. There was a no contact order in place and he violated that. And he was also going to batter her while that was in place.
Yeah. And this, the one in Brevard County allegedly took place within like 2 weeks ago, 3 weeks ago.
I was trying to collect my belongings.
I'm sure they told you to go, if you're going to go to get your stuff, you got to go with law enforcement. You can't do it yourself. Simple, right?
Sure.
All right, I'll set bond on the battery at $500. No contact whatsoever. You've heard that before. With Angelica Henao, Henao. No return to 13011 Penhurst Lane. Must keep a separate residence from Ms. Henao. You can go back with law enforcement one time. Got to call either the local police or the sheriff's office and have them go with you. Can't just show up there. No guns, no drugs, no weapons, no alcohol. I need to set a bond on the contempt.
Yes, Your Honor.
All right. I'll set a bond of $750 on that. Same conditions on that. And keep all your court dates in Brevard County. I think you have one coming up, something in May. And I will appoint a public defender to represent you. Yeah, that's where the contempt is. Your name, ma'am?
Tashiana Ricks.
All right, Ms. Ricks, you're here today because you're arrested for several charges. I have read the charging affidavit. I do find that there's sufficient probable cause. And the charges are attempted armed burglary of a dwelling, aggravated assault with a firearm, domestic violence, aggravated assault with intent to commit a felony, and carrying concealed firearm. Now, where this occurred, if I'm correct, is not your address, is that right?
Right, yes, sir.
That old Winter Garden Road, that's your ex-boyfriend's,
Yes, sir.
right? You got no reason to go back there, right?
Yes, sir.
All right, as to the attempted armed burglary, I set bond in the amount of $1,000. Aggravated assault would be $750, $500 on the other aggravated assault, no, just make that $100, and carry concealed firearm $100. And I'll appoint a public defender to represent you. You're not to possess any guns or drugs, no weapons, no alcohol. While if you do bond out, you're not to have any contact whatsoever with either David Marsh or Legea Young. No contact with either of them. You're not to return to 3732 Old Winter Garden Road. I think there's kids involved?
Yes.
Yes?
They have children in common, but they weren't present, Your Honor.
Okay. Who has the children now?
My sister.
Who does?
My sister.
Okay, all right. So you'll be able to see them there. All righty, thank you.
I'm sorry.
Yes, 1,000 on count one, 750 count two, 100 and 100.
I thought it was 500 and 100.
Yep, what's that?
I thought it was 500 and 100.
Did I? I wrote down 100. What, did I say 500? All right, then that's what it was. Oral goes over what I wrote down.
It's going to be 100, 750, 500, then 100.
So it's 1,000, 750, 500, 100, and PD point.
Okay.
All right. Your name, sir?
Alberto Rodriguez.
All right, Mr. Rodriguez, you're here today because you're arrested on 2 charges, aggravated assault with a firearm and battery domestic violence. Let me get there. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. It's still known here. It's based on a arrest warrant. Affidavit up. Were you residing at the 709 West Washington address?
Yeah, that's my address.
Excuse me?
That's my address.
All right, do you have another place to go?
Yes, I do.
Where's that?
Either my dad's or my sister's.
Okay. All right, I will, do you have, I assume you have stuff there?
Huh?
You have clothes, things like that there?
Yeah.
Okay. All right. That's to count 1, aggravated assault, set bond amount of $1,000. Battery domestic violence, $500. You cannot return to that address except you can go one time with law enforcement to pick up any items you need, any clothing or personal items. But other than that, you're not allowed to be there. You're not to have any contact with Medina Cervantes. No contact with her whatsoever at this point in time. No guns, no drugs, no weapons, no alcohol. And appoint a public defender to represent you.
Defense will waive, Your Honor.
Okay, in Ms. Rodriguez's case, I did find that there's sufficient probable cause. On the battery, domestic violence, $500, obstructing, $100, false imprisonment, $500, and the ag battery with the motor vehicle, $500. Appoint a public defender, no contacts with, can't remember his name. Contact with Christopher Gilbert. It's happened at a hotel, so we don't have to worry about that. She's to keep a separate residence for Mr. Gilbert also. And the PD's appointed. Your name, ma'am? Your name?
Good morning.
Good morning. Your name?
Sonia Turner.
I have PC issues, Your Honor.
Okay.
Only as to the aggravated battery on a person 65 years or older. I believe it should just be a battery on a person 65 years or older. Based on the affidavit, there was wine thrown, but there is no great bodily harm, permanent disfigurement, or permanent disability done by my client. So I'd argue no PC as to the aggravated battery.
State has no objection, Your Honor. The appropriate statute is 784.08 sub 2, but it should be sub C instead of A.
Okay. So we'll find probable cause for that. Now, I know that that was where this allegedly occurred, was your house. Is he still, is your brother-in-law still at the house?
I believe so.
I need to speak up a little.
I believe so.
Because that's going to be a problem. I can't let you go back there if he's still there. Which is,
The whole situation was.
We'll talk about the facts.
is there someone else, another place you can go on the short term?
Yes.
Okay,
And house.
all right. I will, I'll set bond in the amount of $500 on the appropriate charge there. No, you can return to 1220 Priory Circle, Winter Garden, one time with law enforcement to pick up any clothes or anything, and I assume your husband can also help you with that. Bring those to you. You're to have no contact, but you're otherwise not allowed to go back to that address at this point in time. No contact with Stephen Turner, your brother-in-law. You're not to possess any guns or drugs, no weapons or alcohol if you do bond out, and I'll appoint a public defender to represent you. Okay.
So the correct charge was that's 784.08 sub 2 sub C.
That is correct, yes. It's just battery without the aggravation.
Yeah. Mm-hmm. Your name, ma'am?
Danelisa Espinosa.
All right, ma'am, we're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit, and I do find that there is sufficient probable cause. All right, let's see. All right, and your name, sir?
Marcio Pantoja.
You have to speak up a little bit.
Marcio Pantoja.
All right, raise your right hand. You solemnly swear that the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, and you are the alleged victim in the case?
Yeah.
Okay. What did you want to tell me?
This problem. We just had a little discussion and escalated.
Okay. Well, I mean, the allegation is that she did some stuff to you, and then she tried to make it look like you did something to her. That's dangerous. All right, so you have no objection if she comes home, though?
She had anywhere to go? Can you ask if she has anywhere to go?
Okay, well, that's not an answer. That's not your problem. If she doesn't have anywhere to go, that's her problem. But do you want her to be able to come back home? Because I can order that she not come home.
You don't need to put that.
I can't, you got to speak up.
You don't need to put that. She still got to pick up some stuff in the house. So we're good. I'm okay.
And like no contact.
Well, so if I have her come home, then I can make it no hostile contact. That's fine?
That's fine.
Okay. Do you have any questions for him, State?
I don't, Your Honor, but from the comment, it sounded as though he wants no contact and for her just to have the ability to pick up her personal items.
That's fine? I mean, I'm not sure okay. Specifically, you do not want her to come home?
I don't have a problem unless she's okay, you know? But I just want to know if she has somewhere to go before. If she doesn't have, she can come. I'm not a monster.
Okay, but that's not an answer to my question. My question is what you want, not whether or not she's got a place to go, because again, that's her problem. She's going to have to find a place to go. If you don't want her to come home because you think this is going to happen again, you need to tell me that, because I'll just tell her she can't come home. She can go to a hotel, she can call a friend, she can do whatever, but she can't come home other than one time to pick up her stuff and then be gone.
Your Honor?
Yeah.
May we approach on this case?
Yeah. Okay, all right. Perfect. All right, so I'm gonna order that there be no contact So you're not to have any contact with him, okay, Ms. Espinosa?
Yes, Your Honor.
All right. Now you can go back to that. She can come back to your address one time with law enforcement, a police officer, sheriff deputy, someone like that, and then you can pick up all your stuff and then go. Okay. She does qualify for PTR. Does she want to go PTR?
Yes, Your
All right. So I'll release you with pretrial release conditions. Yeah, that means you don't have to post a bond, but you do have to keep in contact with your pretrial release officer. They'll explain that before they release you. Okay.
Yes.
Don't possess any guns or drugs, no weapons or alcohol. And make sure you stay in contact with your attorney.
Yes, Your Honor.
Okay. All right. So she'll come by one time with law enforcement. Okay. All righty. Take care.
You want her to maintain separate?
Yeah, maintain separate residences. All right. Your name, sir?
Gennaro Hernandez.
All right, Mr. Hernandez, you're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit. I do find that there is sufficient probable cause. Nobody's here. All right, so you were not living with Carolina Piamba at this time, right?
No, sir.
You have separate residence completely?
Yes, sir.
Okay. And the 2823 South Orange, that's the Applebee's, I guess, where this happened, right? Allegedly.
Yes, sir.
Okay. All right. Well, I'll set a bond amount of $500, and you're not to have any contact with Carolina Piamba. You can't go back to the Applebee's. I'm sure they probably trespassed you anyways. And you're not to possess any guns, drugs, weapons, or alcohol. Okay? No contact whatsoever.
Yes, sir.
All righty. And I'll appoint a public defender to represent you. Just to order him not to go back to Applebee's is actually a favor to him, quite honestly. I don't know if there's any Applebee fans here, but I'm not a fan. Your name, sir?
Juwan Isom.
All right, Mr. Isom, you're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit. I do find that there's sufficient probable cause. All right, ma'am, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
And your name is?
Ashley Isom.
See, it's not that hard for me to be able to hear people. I don't know what the problem is this morning. All right, ma'am, you're the alleged victim in the case, is that right?
That is right.
Okay. What did you want to tell me?
I just don't want no contact with him, and when he come get his personal belongings with the officer.
Yep.
Personal belongings for his clothes, no
Right.
TVs and refrigerators in my registered truck.
That is correct. That is correct.
It stays in my possession.
Okay. All right. So you're done. You don't want to see him at all?
No.
Okay. All right. Okay, Mr. Isom, I will set a bond in the amount of $500 on your case. You're to have no contact whatsoever with your wife, okay? No contact. And must maintain a separate residence. You can go back to 4704 O'Keefe Street, your house, one time with law enforcement to pick up personal items, clothing, toiletries, things like that. No TVs, none of all that stuff stays. No property in that sense, okay? And then after that, once you've been there, that's the only time you're allowed to go. You can't go back there at all. All right, you're not to possess any guns or drugs, any weapons or alcohol, and the public defender's been appointed, so make sure you stay in contact with your attorney.
Excuse me,
Right.
sir.
Yes.
Also, would you tell him not to contact none of my family members or anything?
Yeah, you can't
Or
contact
go to their
anyone
house or anything.
instead of her. In other words, don't call her sister or mom or anything to talk to her. No contact whatsoever, okay? All righty.
So the TVs and stuff that I paid for, that I can't take my stuff?
Not right now. Now, what I'm telling you is, you're only allowed to go there to get that stuff. That may be part of a divorce, and that of course, will all be settled out later. But for right now, when you go to the house, they're only gonna let you take clothes and stuff. Okay?
Judge, that bond is 500.
Yep.
Thank you.
Your name, sir?
Kevin Revere.
All right, sir, you're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit. I do find that there's sufficient probable cause. There we go. All right, and the Deanna Drive address, is that your address?
That's
And does, Belinda, does she live there?
off and on. It's not our main residence.
Is she there now?
I'm not sure.
All right. I will set bond amount of $500. You're to have no contact with Belinda Moreland. You're to maintain a separate residence from Belinda Moreland. If Belinda Moreland is at 1806 Deanna Drive, you ain't allowed to be there. You can't be there, okay? If she's vacated and is at her other address, then that's fine, but you must keep a separate residence. You're not to possess any drugs or weapons, any guns or alcohol. Okay, and I'll appoint a public defender to represent you.
Yes, thank you, sir.
All right, take care. Yep, one time. Well, he can go back if she's not there, so he maintains separate residence. Your name, sir?
Jesse Clark.
Okay. All right, Mr. Clark, you're here today because you're arrested on a warrant out of county. What's the bond on that?
From a long time ago.
The bond is $2,500, and if you can't make that bond, they will be contacted to let you know that they're being held here. Okay, thank you. Ooh, crashed. Your name, ma'am? All right, ma'am, you're also here on two out-of-county warrants. Are there bonds on those? There are no bonds on those. We will be contacting the other county and let them know you're here, and then they'll transport you. DeAndre Bisfam?
Yes, sir.
All right, did I say that right?
Yes, sir.
All right, great. You're here today because you're charged with violating your probation.
Yes, sir.
And I believe there is no bond on that. Oh, wait. No, he said Bisfam, DeAndre Bisfam. Yeah, there is no bond on that, and I will appoint a public defender to represent you on your violation.
Okay.
Carl Morgan. All right, appoint a public defender. There's no bond on that. Moses Trachtenberg.
Yes.
All right, let me see what we got. Trachtenberg, you're here on a violation of your pretrial release. There's a warrant signed by, I think it was Judge Allen. The bond on that is $1,500. And I will appoint a public defender to represent you if you don't already have one.
All right.
Okay? Were you in pretrial? You were was he in PDD? Is this the one that was in pretrial diversion? And I don't know, but there's a $1,500 bond on that violation. Okay? That is it. That's it. Just yesterday, I'm still shell-shocked. Alberto? Oh, yeah. No, she's not. I put 500, 500, 100, 500. Is that what you have? All right. 33-day motions. State of Florida versus Samuel Lee Simmons Benton, 2023 CF 3310AO.
Granted, notice of non-filing.
State of Florida versus Marcus Henry Clark, 2023 CF 3432AO.
Denied. Information was filed.
State State of Florida versus Gregory Woodfolk Jr., 2023 CF 3505 AO.
Your Honor, a motion for extension was filed. The 40th day would be April 25th. There should be a motion and order that has been filed.
I don't
I'll provide you.
have that.
Which one is that?
On Woodfolk, there's a motion for extension. Let me see if it's in this stack. Yeah, I don't have it.
Yeah, it's not filed. I would object, Your Honor. We weren't notified of we never received the motion. Usually the attorneys assigned would like to be here to argue the 40-day extension.
Understood, Your Honor. This is not the 33rd day. Can you tell me when the order has the 33rd day, please?
Oh, it's tomorrow. 4/19 isn't say the 18th.
I don't think that's the 33rd day either, considering that he was arrested on the 18th. I believe it would be the 20th.
Actually, it says the defendant was arrested for trafficking on March 17th, 2023.
The jail has it as the 18th.
But even if it was, you're right, that would be 33 days.
It's not today.
No. All right.
To have the date on there, Your Honor, of when the 33rd day would be. Usually it'll say to be released on the particular day.
It doesn't say what it would be, but if, let's say they were born there on the 18th. So that would be
The order doesn't have the
14,
date on?
and today would be the 32nd, right? If it was the 18th, today would be the 32nd. If it was the 17th, it would be the 33rd. The 17th, there'd be 15, including the 17th, and then today's the 18th. So what day was he arrested?
The jail website had it as the 18th, Your Honor.
It was March 17th at 23:20.
Oh.
Okay.
So he was arrested, but he probably wasn't at the jail until, because if he was just arrested at 23:20.
Sure.
So it would be, today would be the 33rd day. Is that right? Yeah.
No.
17 would be 15, and then today's the 18th, yep. I don't have the motion, though.
Your Honor, I have a filing ID, so can we recall that one at second session, Your Honor?
Yeah. All right, we'll recall that one. All right, State of Florida versus Mondale San Keel Gray, 2023 CF 3441 AO.
Granted, notice of non-filing.
State of Florida versus Latana Cornelius Floyd, 2023 CF 3344 AO.
Granted, notice of non-filing.
State of Florida versus Marcellus Trey Green, 2023 CF 3484 AO.
Granted, notice of non-filing.
State of Florida versus Leandra Norris Kindred, 2023 CF 1556 AO.
Denied, information was filed.
State of Florida versus Kevin Dion Garland, 2023 CF 3539 AO.
Denied, information was filed.
State of Florida versus Tamir Mikhail Jones, 2023 CF 3167 AO.
Granted, notice of non-filing.
State of Florida versus Richard Allen Russ, 2023 CF 2521 AO.
Granted, notice of non-filing.
And State of Florida versus Marquise Garnell Clairvaux, 2023 CF 3497 AO.
Granted, case was no billed.
Okie dokie.
Two and 2, 7, and 8.
Okay. What time is it? 10 o'clock. What time you guys want to start? Only got, what, 38 for the afternoon.
Is 11:30 enough time?
Fine by me if you guys can do it 11:30. Yeah. Okay. We'll do it. 11:30. So I got what, 38 to something. I already did about 10 of them this morning. So. All righty. 11:30 it is.
Yes. Did you get my email? Hold on. Yes. Thank you. And so I need an order for that one that's coming back. I think he took it. Do you have the case number? The one that he needs an order. He's missing an order for a 33-day motion, a motion for extension. Oh, okay. Thank you. Thank you.
Did you find the motion?
He had the motion, but no order, I think. I don't know.
No, he has our motion, not
He didn't have an order. Thank you so much. Okay, let me fix it. Espinoza. For Moses Trachtenberg, the driver under the influence, he stayed that bond at $1,500. Do you know? Yeah, he stayed Moses Trachtenberg. I got it. Then I gotta set. They put a note on here to set the PTC and dates to order. Okay, hold on. See, I mixed it. I started putting off. Y'all don't know what Sharon done sent and whatnot. Yeah. Okay. Thank you. Did we call David Rodriguez? The out of county for Seminole. Do you know?
Two of them that was on there was they had bonded. He didn't say.
So, which ones have bonded? Thank you, Mary.
Henry Roderick and David Rodriguez.
Thank you. Courtroom. Oh, we're still on record. Thank you so much.